Privacy Symposium, please. For those who are thinking that it is, you probably want to understand what these regional engagements are about. Allow me to introduce to you the head legal and programs at Unwanted Witness, Mr. Alan Sempala Chigozie. It's a pleasure having you. Good afternoon from the Pearl of Africa.
Good afternoon.
Yes.
Definitely, Mildred. How are you?
Great. This afternoon, for many, I actually received so many phone calls and, people asking, so what time is the Privacy Symposium? The thinking is this is the symposium. Get to, let us know about these regional engagements and what they mean as a precursor to the fourth Privacy Symposium Africa.
Yeah, Mildred, Africa is home to 1.3 billion people.
Yes.
That makes
it and still growing.
And still growing. That makes it around 16% of the world's population.
Yeah.
So there's been an increase in the use of internet. And that has given a lot of people, private and government, to get access, to people's personal data. When you use internet, definitely much of your personal data is captured.
Yes.
So that has led to many countries, now 33 African countries that have enacted data protection laws. So, but again, that looks a good number because it's way over 50% of the African countries. But then there is also a growing tendency of non-compliancy of those who collect personal data, at the African continent. There's been a growing tendency of abuse of the right to privacy. So with that need and with that problem, there is need to create conversations around that problem. Because even the laws that are enacted so far, many have loopholes. The regulation is not as efficient and effective as it ought to be. The enforcement has been a problem, So therefore, we thought that it's best to create consistent and regular conversations. And one way to have those consistent conversations is to have these regional engagements.
Okay.
So these regional engagements are a precursor to the Privacy Symposium that will be hosted in Nairobi at the prestigious Strathmore University.
Oh, yes.
Yeah. So like my team leader noted earlier, we are partnering with CPIT Strathmore University to organize this one of a lifetime events,
Okay.
Yeah, so therefore, as many have been confusing, so this is not the Privacy Symposium. The Privacy Symposium is going to be an in-person event. It will be hybrid though, but strictly invite. It will be in Nairobi. But then these regional engagements are more of to drum up support, to drum up, attention to the Privacy Symposium. Now, these are going to continuously go on. We have the first one, the Southern Regional Engagement. Then we will have the East and Central Engagement and the Northwest Africa Regional Engagements. The idea is to create consistent conversations around privacy. Because if we don't do so, then the level at which our policies will change, the level at which our practices, our behavior towards privacy, towards the use of personal data won't change. Okay. So we need to remind ourselves and consistently have conversations around this. And from these conversations, you will have government stakeholders pick up some of the ideas and implement them. Okay. So we can't have this changed if we don't consistently talk about it. There is a problem. Not only the low people who are not educated, who don't understand issues of privacy, but even those who are educated. You can attest to this. Many people can't even differentiate between internet bundle data, data, and the data we're talking about. Many people are still confused. The issue of privacy, the concept of privacy is yet to sink into people's minds, into people's behaviors. And this is not unique. You remember in the early 80s when AIDS had just become, or when AIDS had just come, many people thought it was a rumor.
Yeah, until it struck families.
Then others thought, no, wait a minute, we are bewitched.
The African thinking.
Exactly, they couldn't accept that, look, this is a problem that has come. The earlier we accept it and deal with it precisely, the earlier we'll deal with it.
Alan, someone would be able to ask, what should one expect out of these regional Pan-African engagements that we are having? And what also to expect different, or what will come through at now the fourth Privacy Symposium? Like you say, that's going to happen in Nairobi.
Now, this is the idea. when we have these region engagements, we get to discuss issues privacy that are unique to those regions.
To those, yeah.
But you notice that in these regions, you'll find people, countries or states that are very fast at enacting laws and putting together, infrastructure in order to have privacy and data protection regulated. And then you have these countries who are more of adamant.
Snail speed.
You get my point.
Yes.
I'll give an example. You find South Africa has been very effective. They have a regulator. They have, they have a law in place. They have several regulations, industry-specific regulations that are regulating privacy. And then you have the likes of Malawi, who are yet to even table the bill, if it has been tabled, but that are yet to even table a bill. Then there are those even who don't have the bill. There are those who are actually just looking on. So by having these regional engagements, you have these different countries picking a leaf from each other. If South Africa can do it, so is Lesotho, so is Zambia, so is Zimbabwe. You get it? And you see, we have a lot of problems. It's one thing having a law, and it's one thing actually enforcing it.
Yes.
So those who have successfully, or to some extent successfully enforced it, we can pick from them, learn from them, and see how best the other countries can pick from there.
Okay.
So, and this is not only unique to that region. For instance, the other regions can still listen in and see how does the South African region do it? How do they do it? Then we can pick lessons from each other, and there will build a Pan-African privacy movement that is very strong, and we'll deal with this. We'll deal with the issue of abuse of right to privacy.
Thank you very much, Alan. You talked about two key points that we'll need to be taking: efficiency and effectiveness. It is one thing to have the law and as well have the authorities in place, but it is another thing for the implementation of data protection and privacy to be coming through. So thank you very much. I've been speaking to Alan Chigozie Sempala, who is the head legal and programs at Unwanted Witness. Now, like I said, and like Alan did say earlier on, it was a hybrid event on the third Privacy Symposium Africa. That happened in Kampala, and the fourth is going to be happening in Nairobi, yes. But what happened on the second day of the third Privacy Symposium Africa? Take a look.
Africans are very trusting people, and oftentimes we find ourselves actually willingly giving information with no questions asked.
The national ID has literally become a gateway to access to social services, and I think that is very absurd.
What this means really is that if there's a picture of you online, it could be on your social media profiles, it can be on your professional profiles, it can be on YouTube, then it's very probably in Clearview's database.
Privacy should definitely be a key aspect as we develop these systems.
There is the mindset to provide, some kind of data protection. However, we have fallen short when it comes to implementation.
In a context of the pandemic where there is growing public distrust, where there is public health kind of sort of COVID, people who deny the existence of COVID, one doesn't want to stoke mistrust of government and public institutions. But very often what we're being asked for is not trust so much as faith. And I think it's really, really important at this stage, now that We're looking at a pandemic that has lasted for a year and a half and may last for a lot longer. Public institutions need to do a lot more to slow down, to review all of the emergency protocols, to disclose a lot more information about lessons learned and failures experienced in the implementation of these different systems.
Digital freedom stops where that of the users begin. Nowadays, digital evolution should never or must no longer be placed to a customer in a trade-off between privacy and security. Why? Because privacy is a valuable asset that should be protected.
That was the second day of the Privacy Symposium Africa, the third edition. The fourth edition is coming. We can't wait. November is not too far away. And Nairobi, yes, we are coming and we will have these discussions, especially after having the regional discussions coming through. Now, ladies and gentlemen, online, we're talking about protection. We're talking about privacy. We're talking about the rights. And we are kindly requesting that you will be notified that we are actually going to be recording these engagements that we are paying attention to. So please, whatever you do, just know that you are recorded. It wouldn't be in good faith to just start the recording without getting your permission. So ladies and gentlemen, we'll be taking on the recording of this discussion. But as we do get into that particular discussion, we have a poll question, not one, not two. We have some poll questions that we would expect to have responses coming through. And while we continue with the discussion, yes, you could send in your questions. You could send in your answers to these poll questions. Take a look at some of the poll questions that we do have today that you could be answering. And in just after that, I will be letting you in on our panelists who already you had a sneak peek about, and get to have our discussion and set the ball rolling, for lack of a better word. This is what we have on the poll questions. Which of the following is not personal data? You have to choose one. Students' examination results, location, company registration number. Which of those is actually not personal data? Okay, tell us. The second one is, do you know who to report to if your data is being misused? If you do, you can say yes. If you don't know, you can say no, and we'll get to know much later on. The third question to be answered is how many countries in Southern Africa? I will have that, please, once again, to have our poll questions coming through as we continue. And you can go ahead and answer those questions, answering them and giving us the options that you think about. We'll be displaying part of that information and the answers that will be coming through at a later stage. So ladies and gentlemen, we know that Southern African countries since 2012, 2013, have gone ahead to continue passing more and more data protection laws. They've established authorities that can be able to deal with implementation of these laws. And there is a leaf to borrow, a branch to borrow from many of the Southern African countries. Some haven't been there yet, but they are on the way. How is the implementation of these data protection policies being emphasized and taken on in the Southern African countries? That is going to be the basis of our discussion. And we have the best experts from Southern Africa. And ladies and gentlemen, I can't wait to introduce to you our panelists officially. Now, they always say ladies first, unless there is danger. So allow me to introduce to you our panelists, starting with, from Zimbabwe, I do have Nompilo Simanje. Nompilo is a Legal and ICT Policy Officer, Media Institute of Southern Africa. Nompilo has also been at the heart of campaigns that do promote the right to privacy, free expression, and access to information, both online and offline. And she's also an expert on the intersection of technology and the law, and also technology and human rights in Southern Africa. It's quite a huge CV, so to say, but I'll just do that sneak peek about Nompilo. Second, coming in from another South African country, that is South Africa, none other than Hlengiwe Dube, who is a project manager with the Center for Human Rights, University of Pretoria. Hlengiwe Dube is a PhD candidate and also a project manager with the Center for Human Rights, University of Pretoria. She also manages projects on freedom of expression, access to information, digital rights, and other issues that fall within democracy purview within the Center's Expression, Information, and Digital Rights Unit. So ladies and gentlemen, let's welcome South Africa, who is represented by Hlengiwe Dube. And we are not yet done. Like I said, it's the ladies first. I have from the United States, I do have Nomi Hailu, who will be talking to us much later on. She is Africa Innovation Mradi Program Manager, Mozilla Corporation. And Hailu is the Program Manager for the African Innovation Mradi at Mozilla Corporation, where she manages initiatives, manages partnerships, events, and supports strategy development for Mozilla's work in Africa region. Hailu also has over 10 years of experience in international affairs across policy, campaigning, and program implementation. And she most recently actually went ahead and worked on conflict resolution and peace building, and has a background in human rights and women's empowerment. Yay, let's welcome another one. I can go to the men right now, and of course, they're well represented. From Botswana, ladies and gentlemen, a round of applause. Let's welcome Botswana. We do have Orabile Mudongo, who is a policy researcher and technologist as well. Orabile is a policy researcher and specializes in public interest technology. I'll say that again. He specializes in public interest technology at the nexus of digital governance, policy, and regulation. And currently, he is a member of the Responsible Artificial Intelligence or AI expert panel for the MIT Sloan Management Review. That is Orabile Mudongo, who will be speaking to us in just a bit. From Malawi, yes, that's Orabile that I was talking about just much earlier on. Apologies about the earlier one. We will definitely be getting you the profiles a little later. Let's now welcome from Malawi, Jimmy Kainja. This is where we want to do a round of applause and, you know, some flowers coming through. Jimmy Kainja is a senior lecturer at the University of Malawi. He is a senior lecturer and he teaches media communication and cultural studies. His areas of research interest are media and communications policy, journalism, new media, of course, including our new social media and everything, digital rights, freedom of expression, access to information, and the intersection between media, democracy, and development. Quite a huge CV as well, but that's just a bit that we can be able to let you in on Jimmy Kainja. And we also from Malawi have representation, Bram Fuzulani. Let's welcome Bram Fuzulani, who is the president of the ICT Association of Malawi. Bram was appointed by the UN Secretary General to be a member of the 2022 Multi-Stakeholder Advisory Group, or you can call it MAG, in the Internet Governance Forum. He is currently serving as the president of the ICT Association of Malawi, a professional body that is responsible for coordinating technical and policy issues affecting ICT development in Malawi. Quite a huge CV as well, but we will move on to another of our panelists, coming in from Botswana. Botswana is well represented, and that is none other than Ogoni Mothuagi. I beg your pardon if I mispronounced your name, but Ogoni, I hope you will be able to correct me on the pronunciation of your surname. I want to come to Botswana the next time and be able to say your name the right way. But well, Ogoni is the Chief Executive Officer of Stencil Technologies in Botswana. And that's a Botswana-based regional technology services and software firm with a footprint in Namibia, in Zambia, and Malawi. And he is also a seasoned business leader with a solid background in driving innovation and organizational transformation, employing technology as an enabler. So ladies and gentlemen, those are our panelists that we will be taking a discussion on with, and we want to welcome each and every one of you who has joined us online. This session is being recorded, that we want to remind you, and we want to take on the discussion. The Southern Africa Privacy Engagement today is looking at enforcement of data protection laws in Southern Africa, a reality check. What exactly is happening? Is there effectiveness? Is there efficiency of these laws? Are they being well implemented by the authorities and the powers that be? That's a discussion that we will be taking on. And well, I last introduced Ogone, but I think he will be the very first one I will be speaking to. But a general question to all our panelists. Let me start with you, Ogone. What is your assessment of the data protection and rights to privacy in Southern Africa so far, at least for the countries that you've managed to work in?
Hi, please confirm that you can hear me.
Yes, yes, I can.
Awesome. Well, I think first of all, let me thank you for having me. It's quite exciting to be an active participant in this year's at this conference. You know, having observed the unwanted witness movement, as I call it, coming out of Central Africa, specifically around the Ugandan area, I believe, and then making its way now into Southern Africa. So I think to this latter point, allow me to just say to Dorothy, Alan, and the team there, welcome to Southern Africa. Now, going back to your question, let me just start by saying and being honest. You know, objectively speaking, the regional attitude for this side of the world towards the protection of personal data has been quite frankly sluggish if you compare Africa in general and of course Southern Africa in particular to our international counterparts. And maybe at this point I should single out South Africa as something of a regional pioneer, represented here by Thengiwe, and I'm sure she will speak a little more about that. So South Africa drafted and adopted the Protection of Personal Information Act in 2013, which in itself was a little overdue if we use the international standards as a barometer. Now, if I now bring it closer to home, through what was Act number 32, the Botswana government only adopted the Data Protection Act in 2018. Now, if you take that and juxtapose it with the tremendous growth of the digital economy, it's fair to say, while commendable, it was by many standards way overdue. Because I mean, prior to that, that means that Botswana didn't have any primary legislation that regulated this kind of data. Just to give you a little bit more context, while the act was adopted on the 3rd of August 2018, it only came into effect, and that is to say, as law, on the 15th of October 2021. And the commission obviously then had the task of ensuring that everybody can actually shape up. So it extended a 1-year grace period, and you can call that a dress rehearsal, to October of this year, 2022, for any person or entity processing personal data, allowing them to conform to the provisions of the act. So we're looking forward to that. Some people more than others, obviously. So I think that's something to say. So while it's, I think it's impressive that more countries in Southern Africa have kind of now heeded the clarion call to protect their citizens' rights to privacy. But having said that, my view still remains that there's more that can still be done to unify this compliance at an interjurisdictional layer, for lack of a better word. Thank you.
Let me get to Nompilo. What's your own assessment of how data protection and privacy has been dealt with in Southern Africa? Nompilo, are you able to get us?
Oh, goodness me. I had not muted, but yes, thank you so much for having me. And I'd want to build on what Ogone has just said with regards to the fact that there's still lots of work that needs to be done in the region as far as data protection and privacy is concerned. And I think from a continental perspective, one key thing would be that lots of countries, many countries in the region are yet to signed the Malabo Convention. They're yet to ratify the convention. So from an international standards perspective, there's that aspect lacking. But also there's the issue of acquisition and deployment of surveillance tools in the region, which has also been contributing to the undermining of the realization of standards with regards to data protection and privacy. And Zimbabwe and Zambia are two of 7 countries in Africa that were recently identified as using Israeli technology or Israeli spyware. So these are some of the key concerns that I've had. And maybe just to take that down a notch to the Zimbabwean context as well. In Zimbabwe, we only enacted our law last year, December 2021. So the data protection law that we have is fairly new. And what that has also meant is that there is yet to be a clear enforcement of that law here in Zimbabwe. And unlike South Africa, we did not even have a transitional period that was put in place to facilitate or enable data processors and controllers to comply with the provisions of the law. So that is where we are at. And I think there's lots of work to be done even with regards to capacitating the Data Protection Authority. In Zimbabwe, we did not enact an independent or a new Data Protection Authority, but POTRAS, the telecoms regulator, was appointed to be the Data Protection Authority. And there've also been key conversations around its independence, or that it's now a super administrative power. So those are key concerns also that we have from this end with regards to the state of data protection privacy. And just to highlight also that I think some of the key concerns, especially from a regional perspective, are centered on our existing interception of communications laws. Some of those laws still have provisions that undermine data protection and privacy. So there's lots of work that needs to be done also in addressing those laws and the provisions that are in those laws which do not comply with the principles of data protection and privacy. I'll end here for now.
Context, and I would much later on want to know what's the effect of using this sort of Israeli spyware or software that's coming through, and what the discussion is thereafter. But Jimmy Kainja, let me come to you. In your own view, looking at how your country and the other countries, Southern African countries that you've paid attention to, how is the aspect of data protection and privacy being dealt with? A plus or minus?
Yeah, I think to add on to what the two colleagues have said, especially what Nompilo was saying, I think we all need to look at this from the perspective, maybe perhaps of the governments. That I can imagine most governments in South Africa that they adopt data protection laws, for example, but whether those laws are going to be used for its intended purpose, or whether it's not just a tokenism, it's going to be a different question altogether. Because I think what we see basically is that the more programs that governments are embarking on collecting people's personal data, it doesn't match the ambition of having laws that protect this information. For example, I mean, even before COVID-19, we talk about COVID-19 a lot, perhaps because most people adopted the use of technologies during the COVID-19 because of lockdowns. People have to work online and all that. But if you look at Malawi, for example, Malawi implemented national ID, biometric national ID registration, which is mandatory for anyone who is 16 or over in 2017. In 2018, adopted mandatory SIM card legislation, for instance. So we've had basically programs that is collecting a lot of people's data in absence of data protection law. At the moment, we have a draft, of course. I understand that is now in the Ministry of Justice, but it hasn't been gone to Parliament yet. So we have a lot of data that's been collected in absence of data protection laws. In addition to that, I think we also need to appreciate that if there is no big push, say from the public for these laws, governments are going to be slow. So we may sit here discuss these issues, but it's more or less like non-issue for a lot of people out there. So we also need to pay attention to this fact that for most people, data protection, what is it? Most people don't really get it. So maybe there's also that sort of aspect. So I think we need to focus beyond just having data protection laws in place. In other words, we need to get to a point where governments are compelled actually to play their part in protecting people's personal information. Thank you. Hello.
The moderator is muted.
Yeah, I think she's on mute. I can't even.
Yeah, she is on
Hlengiwe,
mute.
are you able to get me?
No, because
all right,
you
sorry,
were mute.
Hlengiwe, sorry we did lose you right there. Sorry about that technical glitch. But I am coming to you to get the South African perspective of how data protection and privacy is being handled.
Thank you. I was saying I was not able to get you because you were on mute, so that's why. Thank you so much. My name is Hlengiwe Dube. I am representing the Center for Human Rights, which is based at the University of Pretoria. So some of the issues have already been mentioned, so I can just cross-reference what has already been alluded to in the interest of time. So we've already heard that having a law is one thing, but also then its implementation is something totally different. Having a law has its own long, tedious process, and also then the implementation becomes a whole different process altogether. So within the context of South Africa, yes, a protection of personal information law exists. And thankfully also the Data Protection Authority is now in place, which is the information regulator led by Advocate Phansi Hlakula. So it is growing in terms of its work, in terms of its capacity as an institution. Unfortunately, the demands that are required to be performed by this institution are quite huge, and there is a requirement or an expectation for it to hit the ground running. But I think they're really trying their level best as an institution. And it's the demands also, we've heard of the data breaches that have happened in South Africa, quite a number of them. And I'm sure there are many that have not been reported. So that is the kind of volume of work that is expected of the institution. If you go to the law itself and look at how much the function of the information regulator, it's quite a very huge mandate. So it's what I'm referring to here is that it requires a certain level of resourcing in terms of its capacity, and also the financial resources as well. So in as much as it is functioning, it could be better resourced as well. And so because this mandate, like I've said, it's quite huge. There's an awareness mandate, there's an enforcement mandate, among other things. But we have seen instances where the regulator has really stepped up and provided guidance in certain areas. If you go to their website, you will find that there is stuff around political parties in the electoral environment. There is also a guidance note on children. There was also a guidance note that was issued during the COVID context, and also there were other processes that were also adopted during the COVID context that ensure that protection of personal information is upheld, and also the appointment of a designated judge to specifically look into those issues. But again, the development of a culture of lawful protection of personal information is quite a process on its own. Jimmy also mentioned the issue of knowledge gaps. It is still a reality here that to get to understand the nitty-gritties of the law itself and actually develop the necessary systems that are required to effectively implement the law. You know, this is something that is still at the nascent stages and still requires a whole lot more effort. Institutions require issues, you know, to adopt certain data governance frameworks, to develop certain institutional structures, to adopt certain technologies, to develop policies, and also with the relevant expertise as well. And all this is happening within the context where we are using more and more of technology, and even the risks that are brought by technology are becoming many and very often. And this also affects information, the credibility of the information, the integrity of the information, or the confidentiality of the information, hence the many data breaches that has been experienced so far. So there's that issue as well, that, you know, you're trying to implement the law, but there are all these cyber attacks that are also happening, which also compromises the issue of the level of implementation or the quality of implementation. And also you will notice that there is the access to information law, and there is also the data protection law. So there's also a need to have that understanding of how to create that very delicate balance sometimes when you're looking at both rights. And these mandates, they sit both within the information regulator, which is the same institution. But again, recently I was having a discussion with a colleague on an example of the elections environment, where in terms of electoral transparency, you would require the electoral management body to proactively make available the voters' roll to the public. But then what are the privacy implications? What are those issues that we have to consider when you are balancing it with the requirements of the protection of personal information vis-a-vis the requirements of the other law as well? So those are some of the issues that are to be taken into consideration, or that are playing out as South Africa is implementing the law. Issues around security of information, the integrity of information, the adoption of, because when you're taking down to the internal, at organizational level, the internal standards, the internal structures, the internal policies, the ways of controlling data, the ways of developing data, it's a whole big ecosystem that is still developing. And there's also for organizations, you will find that this is like an additional layer of responsibility, which requires its own resources, which requires its own internal mechanisms, and organizations are in the process of developing those so that they are in full compliance with the law.
I will also be coming back to you just to get deeper into the context of how South Africa is dealing with this and the laws and how they've been implemented. Let's now get to Bram from Malawi. Bram, in your own view, is Southern Africa doing a good job, and Malawi being part of those?
Yeah, I think so. From the context of the Southern Africa, there are many examples that have been shared in terms of the legislations or countries that have passed legislations with regards to data protection and privacy. Maybe an area that we need to also focus as civil society organization, but also different stakeholders, is the area which I like. I've always wanted to drum more support towards. You see, when the laws are being drafted, most of us, civil society organizations and different institutions, except government, we are always late to the party. We're always late to the party in the sense that we want to raise issues that should have been considered during the drafting of the law. You know, when the draft is in place or the process has been, put in place, I think most of us shun away, to come to the table and look at the draft and give our input before it's too late. That is I think very critical, not only in Southern Africa, but I think within Africa itself. We should begin to advocate for good legislation. I think there's a discussion whether when you have the data protection law in place, who is going to be the commission? Who is going to be the authority in this context? Is it going to run with the state agency, and then there's a fear of if it's left to the state agency, then they can use it to their own advantage. They can also collect data for other political, political enemies, the opposition parties, But if the stakeholders, are involved in the process of drafting, I think we can avoid some of these mistakes. That is number one. Number two is now we also begin to just focus on all the police or the law enforcement agencies are not doing enough because there are people who are being exploited. There are people whose data is being used without their consent. But we haven't educated or civic educated the masses in the rural areas, in the remotest areas of our countries, in Zambia, in Mozambique, so that they are aware of these issues. You would find that in most, my perfect example is if this was actually a physical meeting, you always have a photographer who is going around taking pictures, and no one actually asks them and say, "Oh, don't take my picture," because you need to give consent. These are some of the obvious things that we need to go out there and even, civic educate people. Just getting to an event and someone is asking you for your details to register on those forms, put your name here, your contact details. Who is going to use it? You need to consent. So, yes, we have been very vocal on asking our governments to make sure that they put in place policies and legislations. But I think we need to go back and also look at our communities. We need to go back and get involved at the forefront of drafting these legislations as civil society organizations to amplify the voices of the voiceless. Thank you.
I'll definitely be getting back to you in just a bit. I totally love when you say that at which point are the other stakeholders involved in the discussions about these privacy laws. I think that is very key, that it should be from the very beginning. Let's get to Hailey from the US in just a bit. I would like to know that since we're talking about data protection, there are a number of channels or digital platforms that we are using from the United States. You can mention it all, WhatsApp, Facebook, Instagram, everything. But the question is, while we are discussing data protection in Africa, in our different countries, in Southern Africa, how are these going to be affected and how can we bring them on board? I know currently that Uganda, for example, is having discussions with Facebook on matters, not just revenue, but also data protection and that. But Hailey, let me get from you. What is your assessment of data protection and privacy in Southern Africa from the studies that you've done?
Hello, good afternoon. I'm really happy to be here at the Southern Africa Privacy Engagement event, talking about the enforcement of data protection laws in Southern Africa. I'm honored to be here with my esteemed fellow panelists. It's great to share this virtual floor with you all, and thank you to Unwanted Witness for the fantastic job in organizing this. So in response to my assessment to the state of data protection and the right to privacy in Southern Africa so far, I'll briefly share my perspective as someone who is a member of the African diaspora, but from and based in the United States. Working for Mozilla, a global tech company whose core values include privacy, and working specifically to promote a framework Mozilla uses called the Lean Data Practices, what's become apparent to me is that there's a global trend towards greater data protection legislation taking place, and this is also the case across Africa. And Southern Africa specifically have policies or draft policies at a higher rate than the average of the rest of the continent. So that being said, having a policy outright is not necessarily the end goal, because it's also important to have the right kind of policies that safeguard users' data and their privacy. We have seen that cybersecurity laws and data protection laws proposed in the region can sometimes infringe on individuals' online privacy rights. which is a concern that is certainly not only limited to Southern Africa or Africa generally, but many countries and regions across the world face this issue. And beyond having the right type of policies on the books that properly safeguard users, the next step after moving into a policy is the implementation, and that's often really a challenge to do so. One last point that I'll share is that with the Africa Continental Free Trade Area, there's a lot to navigate around cross-border data flows, and the need to harmonize data protection and privacy rights across African countries will be paramount in the adoption of the AFCFTA. Thank you.
Thank you very much. Haile will definitely be coming back to you in just a bit. Maybe for that particular one, for the bigger outlook, for the sneak peek, let me get to Orabile. Orabile, what is your own assessment of aspects data protection and privacy in Southern Africa, with context of what is happening in Botswana?
Can you hear me? Yeah.
Yes, yes, we can.
Okay, super. Thank you so much for that question. Perhaps in response to it, I just wanted to actually, indicate how much I share the same sentiments with other panelists in this discussion as well. But from a general perspective, I think, looking at the data protection landscape across Africa, you realize that it has undergone the significant changes over the past decades. And there is this, increase in the adoption and implementation of data protection laws, as well as, different frameworks by various countries in the region. But what's really interesting as well about this kind of developments, you're seeing also some regional bodies, across the continent, as well as, globally, coming up with this kind of developments into effect. For instance, globally, the GDPR, as well as, the African Union with the current data policy framework. But what's really interesting about this kind of developments at the same time is that, with this kind of rise in digitization as a result of, COVID-19 pandemic, the broad implementation of such, privacy laws across the continent, even in Southern Africa, has never been more urgent, basically. And, countries like Mauritius, South Africa, Zimbabwe, and now Botswana, they've been really implementing these new measures to protect and secure the personal privacy and information of their citizens. But in general, existing data protection laws across SADC countries, they kind of really, offer these provisions that cover the majority of principles and data subjects that are, also included in your GDPR. For example, most of these laws, they have this detailed provisions on the data subjects, on consent, as well as the lawfulness of processing personal data, instances of data minimization, as well as storage of limitation, amongst others. But I think what's really key for me in this kind of discussion is the gaps that are actually existing within existing frameworks, where there's this kind of lack of functionality and management of legal practices across the African continent in general, which really provides a lack of sustainability and practicability, applicability of this very same frameworks in the local context. I think I'll take it back to you. Thank you.
It's very key that those gaps are definitely the recipe for the lack of sustainability, and also not being able to continue to implement to the latter the laws that have been enacted in the different countries. Now, let's put this in context, and I'm coming to you, Ogane. when you look at we're talking Southern Africa currently, but we cannot let out, for example, e-commerce sites, social media sites, and even just search engines that are located in the United States. If you can say Microsoft, Google, if you're talking at eBay, if you're talking about Facebook, and all these other social media platforms. Now, the US trade perspective, in the US trade perspective, many of the laws that we are enacting in Africa already, those that are existent, are likely to impact a variety of such digital sectors. Now, the question that comes through is, what effect will the establishment of these data protection laws, or those that are already in existence, have on the way some of these firms get to not only use the data, but also share it and have a sort of harmonization between the US and the African countries? Like I put for you in context, Uganda currently is in talks with Facebook over something the same, not only revenues, but also data use and management.
Thank you very much once again. Well, look, I mean, historically, putting up a billboard was, if I can use that example, was akin to kind of sowing seeds through that age-old method called broadcasting. And there was absolutely no way of telling what's going to stick and what's not. So the transition to digital allowed marketers to know exactly how many eyeballs have seen the billboard, quote unquote. And furthermore, you can tell exactly who these people are across many different dimensions, whether you're talking socially, culturally, spiritually, the list is endless. And of course, that can be quite truly powerful, commercially speaking. Now, to your question, the main objective of the establishment of these laws is really to keep in check this free range utility of personal data by the corporations. And of course, we have now seen kind of a change in posture following the tightening of some of these rules, mostly in the West and now kind of permeating to our side of the world. We've seen an observable attitude shift in favor of the consumer, of course, in the way that big tech currently handles personal data. Although there still remains some loopholes that they grab onto in order to appease the regulations while furthering their commercial means. I mean, we talk a lot about consent, and I think there's no conversation on data privacy that doesn't have consent littering about 80% of the vocabulary. But consent can also be as clear as you want it to be, or it can be as gray as you want it to be. And most of these big tech companies have started to use it as a tool to serve their own ends while actually being compliant at the same time. And I think these are areas that will need to be looked at in the context of conformity and compliance. I mean, if I give an example of purchasing a 2,500 iPhone, the first thing that the company will do is they'll give you a 36-page point size 6 privacy policy, at the end of which you basically, that's how I read it, you concern or turn this device into a brick. I'm not sure we can call that consent in the good faith that the data privacy laws actually intended it. So I will stop there, but I think that's basically some of the things that we need to look at, particularly in relation to what we refer to as big tech and how they handle our data. Thank you.
All right, thank you very much, Ogone. Sorry about that. Probably many of us kept waiting to see. But the fourth Privacy Symposium Africa will be coming through in November. Nairobi, we're coming. But this is the first engagement of the Pan-African engagements that we are having. And today our discussion is on the perspective of data protection and privacy on the Southern African perspective. And of course, we're having very brilliant discussions that are coming through. Nampilo, Zimbabwe, let me come to you now. For long, like I said, the African data protection laws have been known to be non-punitive, more like lax, and that is probably one of the reasons why we do not have as much efficiency coming in from these laws, and whoever is taking the data is using it as and how they would want to be. Now, could this be the beginning of more punitive data protection laws in Southern Africa, having seen, for example, what happened in April 2022 when the National Data Protection Agency of Angola did announce that a government-owned bank in the country had to pay off an equivalent of over $525,000 over violations of articles in their data protection.
Thank you very much for your question. I think what I want to emphasize is that most, if not all, of the data protection laws that we have had do have provisions that speak to what remedy will be put in place in the event of breach of some of the provisions on the position of the data processors or data controllers. So I think what we are now seeing is enforcement of those provisions. So in most of the data protection laws that we have had, you normally have a framework that speaks to the standard and principles that data controllers and data processors should adhere to. But thereafter, in enforcing the law, even Hlengo, I think she mentioned that, and I think it's something that has happened also in Angola, that several regulations have then been enacted, which then elaborate in terms of what standards should be put in place or what mechanisms should be put in place. And as a result, what remedy or what punitive measure will be a result of any breach. So what we are seeing is some level of enforcement of some of these laws. And I think it's very important because it sets a precedence in terms of the data protection laws. And I think it's something Hlengo touched on and the other panelists, that it's one thing having data protection laws, but it's also very important to then have enforcement of those laws so that we realize data protection and privacy. So I think an example has been set, and it's important because there are key principles in these laws to which data processors and controllers should adhere to. And if we look at what happened with that bank in Angola, one of the, what it had done was that one of the articles that it had violated related to notifying the authority before processing or getting authorization from the authority before processing data, and it did not do that, did not comply. So it's important because corporations are some of the biggest or key stakeholders protection privacy is concerned, and it's important that they comply with the provisions of the data protection laws. And also, I think what is key is that, for example, if you look at South Africa, Hlengo mentioned it as well, that there have been several data breaches. And I think sometime in 2021, the authority mentioned that there had been over 139 breaches that had been reported. So in one of the cases, the regulator has been putting to task one of the credit bureaus for repeatedly offending or repeatedly violating the provisions of its Protection of Personal Information Act. So in instances also where corporations or controllers and processors are repeatedly violating the provisions of the laws, I think it's important that we should have this framework or this capacity to then have this punitive measure enforced. I think that would be my contribution for now in terms of where we are headed.
All right, Jimmy, I now want to bring into context the journalistic perspective and the tenets of journalism. Now, I know one of the key principles of data collection is basically what the information is going to be used for. So you're probably collecting my data to be able to store it as staff or to be able to buy goods. So you need to know my credit card number and all that stuff. But How are these applicable in journalism? Because if it is personal information, then it doesn't have to come out as easy, as much as possible, because it's private, it's personal information. You collected it for something that you needed to get. And is that being practiced in the aspect of journalism in Southern Africa? Jimmy?
Hi, sorry, I'm still muted. I don't think I would pick out any specific case to say, to speak to that question specifically. But you wouldn't rule it out because how journalism work, basically there are several ways in which people can access information. But I think when you think about journalism itself and data protection, I think this is where we go back to the question of having data protection laws, because you have to have points that are clearly spelled out. What information can people have access and whatnot? And we know that we also have to strike the balance between protecting freedom of expression, protecting the right to access to information, and protecting the right to know that if the public have to be informed, then you have to make way, you have to provide room for journalists to get information. And that information should not just be PR-based information. We're also talking about information actually that others may want to hide, information that others may want not the public to know. So there's information that you can get readily available in public places. There's information that you also have to find through other means. So looking at data protection and journalism, I think there's a thin line that we have to define between protecting freedom of expression and also protecting people's private concerns. And of course, we know that much as we can discuss about freedom of expression, but journalism also have an obligation to protect private citizens. If information doesn't concern the public, if information shouldn't be public, then it shouldn't. So yes, I don't really have specific cases, but then I think asking that question also highlights the fact that when you're discussing data protection is beyond just thinking about personal data, but you also have to look at issues of public concern. So these are the issues that we have to think about in that sense. I'll stop there for
Oh yeah, maybe Jimmy, just before I let you go, I think I love when you say that it's not just data protection, but the consent itself. For example, I think it was Bram who mentioned if it was a physical engagement, there would be a photographer going around taking pictures. So I am a journalist, I am at this particular event, it's probably of persons who are differently abled. And because I need what is called the footage, I am taking the information in terms of pictures, and I'm going to use it without necessarily having to go to get their permission. Where does the line draw between, having the consent and not being able to deprive them of their privacy, but yet still I need to use that? Because if I'm doing a story about differently abled persons, there is a bit of the footage, the pictures that have to go along with the story.
Yes, I agree. There's a lot of that. I'm not sure about other countries in Southern Africa, but I know in Malawi, for example, go for, say, for example, an engagement like this one, if it was physical in some hotel or whatever, there are people taking pictures basically without having actually asked people if they may want their pictures taken. So I think from a journalistic point of view, there are different issues that we have to consider. That you may have a media institution that is well established, nation media, for example, in East Africa. But then increasingly also having the so-called citizen journalist, anyone can take pictures, anyone can publish anything today. So the different ways of looking at it, if it's an established media institution, perhaps media institutions themselves also have their own institutional policy. They have their own safeguards and gatekeeping processes. So you'd assume a media institution with their name would have those safeguards in place, because by the end of the day, they also want to avoid lawsuits and so on. But perhaps maybe the difficult part becomes when in this day and age, because of the technologies that we have, anyone can take pictures, anyone can use those pictures. I'm not entirely sure how legally that would work, but I would insist that you don't use not just pictures, but any other information from people without their own consent. I think that should be emphasized.
All right, thank you very much. I also do see a response from Fatma Haruna Songoro from Victory Attorneys and Consultants in Tanzania, who says they've been writing quite a number of articles about data protection and privacy, and she has been able, he has been able to share that some of those links right there. So please make good use of those and see what has been happening in Tanzania and what those particular articles have to say about data protection, the kind of subject that we're having right here. Hile, let me come to you. In South Africa, you have what they call the Protection of Personal Information Act, or for lack of a better word, could say POPIA. And this took effect in 2021. Also having a grace period through which there was a compliance sort of aspect from the different other organizations. But what seems to be coming through is that, for lack of a better word, let me say that companies are struggling. And if there is any investigation point for some of the bigger companies in South Africa, it's going to come through on the aspect of data use and protection. Now, how hard is it, or how hard has it been for these organizations to operationalize POPIA effectively? And what reasons are they actually given for failure to operationalize it? Hlengiwe?
Yes, yeah, thank you. So for a moment, I thought you were referring to someone because you came up with a different version, but it's fine.
Okay.
It's okay. So yes, I've already alluded to some of the challenges in my first submission. So like I said, the issue of enforcement and implementation, it's a whole process. It's a whole loaded process on its own. And to say South Africa is well ahead of other countries, yes, indeed, that there's a law in place, there's an oversight body in place. But in terms of actually the practicalities of it, you find that there's still a lot of work to be done. In my previous submission, I mentioned that the actual implementation requires specific internal measures or organizational measures to be adopted. And these could be in the form of human capacity. This could be in the form of adopting the relevant technologies. And like I said, it's also an extra layer of responsibility for organizations. So there is that transition to adopting such measures, which will then ensure that there is that adequate implementation, or that effective implementation that is required. And the other thing also that I mentioned was the fact that the organizations are still managing this, and it's an organizational strategy measures that have to be adopted and implemented. So if you go into the actual organizations themselves, you will find that there are some organizations that still do not know what exactly to do with POPIA, like how exactly to go about it implementing, who still do not know what the importance of implementing POPIA is, and if there is any importance to their business or whatever they are doing, how should they go about it? So there is still that gap, and there is need to then have led by in the information regulator and also other like-minded organizations to then delve into the nitty-gritties of this POPIA and assist organizations on exactly how to go about the implementation, because that is where the gap is missing. You will find that some of them now end up transplanting privacy laws or data protection laws without really necessarily understanding what the specific importance is, and or without probably adapting them to their organizations, which becomes very difficult to implement when you are copying and pasting. But what is needed actually is there cultivating the culture of data protection, cultivating the culture of protection of personal information. So there is a whole lot, and there are organizations as well that will struggle with this, because some of the requirements, especially to protect the integrity or the confidentiality of the information, would require a certain level of resources or certain technologies which organizations might not immediately have, but this is a process that they might be working towards. And then also the issue of the organized, the digital risks or the cyber risks that are being experienced, which also compromise what these organizations or these responsible authorities or entities or parties will be working towards in terms of compliance. There is, your efforts as an organization, but there is a whole world of criminality that is playing out, and that creates risks around the security of the information, which is a very important attribute of data protection, that information, whilst it's being processed, it also has to be secured. But now that we are in a very digitized world, issues around cybersecurity are also very important, and these are also issues that organizations are grappling with in terms of embracing them and adopting them and actually coming up with specific and practical measures. But also the issue of the knowledge gap being also one of the issues to consider, and also just prioritizing the issue of privacy in data protection. So there is need, I think. I remember having a conversation regarding some of the specialized information, such as children's information, that, when you go to entities such as schools right now, and just check the level of understanding that is required, or their level of understanding when it comes to POPIA, you find that is very low. They do not think that it's still viewed as that law that is there, but it's still an abstract. To actually bring it down into the school system, an individual school, let alone the ministry itself, it's still a long way to go, and there's really need to look at the implementation or the enforcement sector specific or theme specific and all that, to get to that point where we can say there's optimal compliance with the law. But for now, there's still a lot that's still yet to be done.
All right, thank you very much, Helengiwe, for that. And I think you raised very key aspects, especially in government and the enforcers themselves assisting these organizations to implement exactly how, put in place the guidelines. This is how you should be able to implement POPIA, and how, and also come through to help them not only to use the stick, but the carrot and stick approach. Sometimes the carrot has to be able to apply. Bram, let me come to you. Africa is excited about the African Continental Free Trade Area, immense opportunities, although there is a lot of discussion that is going through about homogeneity of some of these products with the different African countries. But that aside, the 52 countries that are excited and are going to implement the African Continental Free Trade Area, one aspect that is still a bit silent is the digital trade. And yet, in actual sense, it is going to happen. Information is going to be shared, which we do not know how exactly it is going to be used. And it is a tale of two worlds. The countries that have immense, laws and data protection policies and mechanisms in place, yet others are still taking baby steps at that. Now, how can we have the African nations form these different policies that can govern the digital landscape and be able to promote trade, but as well as putting privacy, data protection and privacy into action? Bram?
Yes.
Able to get us, Bram? Oh, yes, take it up.
Yes, I'm able to get you. Thank you. It's a very interesting conversation. I think there was a survey which was recently shared where Meta was actually projecting how Africa would benefit to the emerging technologies, the digital world itself. But as you're putting it, we are also faced with a dilemma of how do we strike a balance between protecting data privacy and protection, as well as making sure that we also take part in the digital economy itself. Our policymakers have been slow in terms of enforcing some of the international conventions and laws. I think there was a mention of Malabo, for example, convention, which a lot of countries have yet to ratify. We have seen examples how the colleagues in the Europe have done it using the GDPR, for example, and that has disciplined pretty much the giants in the technology space to make sure that they are not taking advantage of the data subjects as they are collecting the data, as they are trying to bring their digital solutions in those countries. This is where I think not just looking at the regional aspect as Africa or Southern Africa or West Africa, but collectively as at the Africa Union level, how do we, not just for the Africa technology companies, but how do we strike a balance when these companies are now coming in Africa, collecting the data and processing it to ensure that the protection of data subject and the privacy are amplified at the same time, making sure that Africans, especially indigenous technology companies, are also at the forefront participating in this digital, in the digital economy. That is where we have seen very little. I mean, maybe I could be talking from the Southern Africa experience of the advocacy, to come at the forefront, especially the civil society organizations, academia, to advocate for better technology innovations, but also that protect the at the design center of it, protecting the data privacy of the data subject themselves. Because remember earlier I mentioned that we are always at the forefront or at the end of saying, oh no, this technology does not take into consideration issues of privacy and protection. But if we can begin also to advocate for these innovations that are coming in as we're taking part as Africans in the digital space, the metaverse and the cryptocurrencies, how there's a question actually that is going around that I think the next big thing that is going to be to happen on the digital space is the metaverse platform. Now, who is going? I mean, metaverse is about a digital world, a virtual world, where we can have a different experience altogether. We can interact, we can, play games, but this is a virtual world, not a physical world. But the question is, who is going to be responsible to regulate how data is collected and processed in that digital or virtual world? In a physical world, we have these legislations, we have all these conversations going on, but in a virtual world that is now taking the center stage of the digital economy, who is going to be responsible for crafting policies that regulate how data, because in a virtual world, you also have your own sort of identity. How is that going to be protected? How is that going to be the data that is collected in the virtual world processed and protected in as far as we're protecting it in the physical world? So those are some of the conversations that we need to begin, and we haven't done much work. There's a lot that needs to be done in terms of seeing that policies and discussions are going towards that direction. Thank you.
All right, thank you very much, Bram. I agree with you that we need to look at technological innovations in a totally different way, encompassing all this. Now, Hailu, looking at the scorecard, I was paying attention to the Unwanted Witness Privacy Scorecard report of 2021, and it observed something that I've always asked myself, that all this personal information about myself that I'm providing, what are you going to use it for? You're asking about marital status, you're asking about height, you're asking about weight. what exactly are you going to use all this information for? And I know that Mozilla paid a keen interest to this and to this kind of behavior and introduced what is called the Lean Data Protection Curriculum. Now, Hailu, I beg your indulgence on telling us more about this Lean Data Curriculum and how it actually impacts data collectors, especially on the African continent. You get only that which you want, not everything and anything. Hello?
Yes, that is absolutely right. So often organizations will collect more personal data than what is actually needed to provide the service or the products they're delivering. This can happen for a variety of reasons. Perhaps they don't realize that they're collecting unnecessary data, or maybe they want to collect more data in case they think that they might need it down the line, that it might become useful in the future. And so at Mozilla, we practice something called the Lean Data Practices. So we only collect the data that we need to make the best products. The Lean Data Practices can help you be smart about how you collect data. It will help you build consumer trust, and ultimately it can help you grow your business. The framework of Lean Data Practices is broken down into 3 different pillars. The first one is about engaging your users. The second is around staying lean. And then the third one is about building security. So for the first pillar of engaging your users, this is all about keeping your customers informed and empowered about the data that you're collecting and why. So some of the questions that this pillar prompts you to ask is, do your customers know your data practices? Have you put your data collection in context of the situation around you and what service or product you might be providing? Can you provide more choice and control to your users around the data that they might be giving? Can you make your privacy policy more accessible? Do you need a transparency report? The second pillar around staying lean is around thinking through if all of the data that you collect delivers value. The first question around this pillar is, do I need this data to provide the value I'm trying to deliver? What data do you have? How do you collect your data? Why are you collecting this data? And also, when do you delete the data? So this framework really goes through the entire data collection lifecycle, from collecting data into data deletion, and provides some steps, some questions, and a toolkit to walk you through all of those. The third pillar around building security is to learn how to protect customer data. This is becoming increasingly important with data breaches and the certain policies around safeguarding data. And so this pillar and the Mozilla Lean Data Practices framework can really help you make sure that you're thinking through the security measures in your organization, asking questions like, how are you protecting customer data? Who has access to your data? Where is your data handled? What security measures do you have in place? And what will you do if there's a problem? And so what we did is we took this framework, my colleagues and I, and we created a Lean Data Practices course that is now available on the Udemy learning platform. We tailored it specifically for startups and entrepreneurs in Africa, using Africa-based companies as case studies. The voiceovers are with African actors. And some of the key things that you can learn in this course is around understanding terminology such as personal data, multi-factor authentication, data lifecycle, and applying these terms to your organization. The course also helps you distinguish your data in your organization that it could, if used in the wrong way, be harmful to others. It goes through these 3 principles of Lean Data Practices around staying lean, engaging your audience, and building in security. And then importantly, it helps you apply these Lean Data Practices to your technology, to your company, to your policy processes to reduce the likelihood of harm and improve customers' understanding of how their data may be handled. So the reason that we have this focus for this course around the African region is I work at Mozilla on a program called the Africa Innovation Mradi, Mradi being Kiswahili for program, which focuses on Mozilla advocacy and policy issues such as connectivity and access, explores product localization, and seeks to support innovation across the tech and startup ecosystem in the region. With the growing trend of data regulation policies and laws coming up around the continent and at the African Union level, this Lean Data Practices course can serve as a useful resource. It can be a roadmap and a toolkit for organizations and individuals to start to understand the importance of good data management and provide concrete tools to apply that in their organizations. Thank you.
All right, thank you very much for that. I think you bring into context a very important discussion, especially when you talk about organizations getting to ask themselves, do they really need this information? But also for the users having the choice and control of the data that they do get to provide. I think that's a very important aspect to pay attention to. Orabile, let me come to you in the context of, in relation to deployment of artificial intelligence, because I mean, we're talking about the fourth industrial revolution, we're heading into artificial intelligence, using robotics and all that which is coming through. Is the motivation to adopt artificial intelligence only to save money and time, or are we thinking about the privacy of citizens as well? Because we tend to think about, you know, each and every little penny and the time that we spend doing a lot of things that artificial intelligence could save us with, but probably are forgetting about the aspect of privacy.
Yeah, I mean, thank you so much for that question. Perhaps maybe, you know, here's something to think about in this discussion here. If indeed AI is to transform our societies and economies, I think we need to put into consideration the effects of digital transformation and how they are already altering the way our society functions. Then I think it makes sense for us to discuss these issues in the context of socioeconomic and political perspective, privacy, as well as data governance. But then again, these issues, I think, they're actually that important in today's, you know, globalized and digital economy. Of course, you know, these are clearly questions well worth our consideration in this discussion. In relation to the deployment of AI and what the motivation is, I think, you know, there is no doubt AI is rapidly proliferating globally, and Africa is no exception to this. Startling developments keep emerging where big tech companies harness AI capabilities to kind of improve their analytical processes, whereas most governments as well kind of tap into these technologies to accomplish a range of policy objectives, some of which are lawful and others, you know, keep on violating human rights, and many which kind of lack clarity as to what purpose they serve. But to provide you with some greater clarity, empirical data from the research I conducted in the AI in Africa policy project shows that, you know, AI deployments in Africa are mainly driven by smart city initiatives, such as facial recognition, safe city initiatives, your CCTV deployments in big cities, as well as AI surveillance as tools to monitor, surveil, and track citizens. But in order to appropriately address the effects of this technology, I think it is important for us to first understand where these tools are being deployed and how they are being used. But although it is hard to kind of distinguish between legitimacy and unlawfulness, in terms of usage of AI technologies, I believe this discourse will help us to kind of really understand the capabilities of these technologies and how they are transforming the abilities of governments and big corporates to how they function in our society. But in terms of the adoption and that gray line between privacy of citizens, I think framing AI through an African lens in this instance, Africa is kind of playing a central role in the global AI supply chain, particularly in the production phase, where we have kind of become consumers and a testing ground of these technologies. Yet these big foreign AI technologies dominate in the region, procured through public-private partnerships between government and this private companies, you find that big tech companies that offer these technological products and solutions often are not compatible with, local development priorities. But at the same time, the pressing privacy and human rights related issues these technologies highlight, I think is that, these tools are often used as tools of repression and social control, which ultimately violates, civil liberties such as, your freedom of movement, association, as well as, equality and fair treatment. I think, looking generally from how these issues relate to privacy, you find that, there are kind of less than 5 African countries right now with existing national AI strategies. However, some of them are kind of really include provisions around data protection legislation that recognizes AI as a tool for data protection. And I think it is upon government and other other stakeholders to kind of really come to a common ground and understand that AI technology has a role to play in terms of compliance and data protection standards within the region. In terms of AI surveillance, interesting enough, governments often, and also many of private companies actually purposefully hide their surveillance capabilities in some instance. And as such, it has really become difficult for researchers and also civil society to precisely determine the extent to which these governments are deploying algorithms to support their surveillance objectives, or whether AI usage is more speculative than real. But I want to depart from this submission with a point from the OHCSR inaugural report on privacy and the digital age surveillance. It kind of highlights a lack of adequate national legislation and also enforcement or weak procedural safeguards and ineffective oversight mechanisms, which actually diminishes accountability and fosters this kind of condition for unlawful use of AI technology by our governments as well as private companies they engage with. Thank you.
To go with now, I love when you talk about that the framework of African, I mean, artificial intelligence has to put Africa into perspective, because we've become consumers and then a testing ground. But then with the adoption of artificial intelligence, Orabile, will we then have this data protection law still relevant?
I think I would like to, partly agree with your question somehow. Of course, having these data protection laws and policies in place is quite relevant to this emerging digital policy as well as developments we are witnessing in the continent. But at the same time, I think we need to kind of really define what exactly this technologies are serving our societies and how they will impact the way the society functions. Hence, I was emphasizing the aspect of improving our oversight mechanisms in terms of putting in place committees that kind of vet this kind of technologies and how they impact the society, and at the same time how they can add value to the economy.
All right, Orabile, thank you very much. We'll definitely be getting back to you in just a bit. And I want to just remind all those who are attending that we are recording this particular session, and we would like to request that you are in the know of that one particularly. We earlier on had an opinion poll, and you can be able to participate in that opinion poll, or there are 3 questions that were coming through, and we will be displaying the results much later on. And as well, in that opinion poll, we have questions. If you have any questions that are coming through, please send those questions in the chat box. We already have a few questions that are coming through, and we will be sharing some of those. And you can direct your question to a particular panelist who you want to be able to answer this particular one. And maybe I earlier on did see something coming in from Karen Smith. I do request that we continue to respect each other. We are all using this space, and there is a lot of human rights that has to go. We're talking about rights, so I just wanted to pass that on, that we shouldn't be able to distract each other from the core of our discussion, which is data protection and privacy. Ogone, let me come back to you now. Southern African countries are actually now working tirelessly to be able to update or create and laws and regulatory practices with regard to data protection and privacy, and ensure that there is privacy and the rights reserved and protected for the consumer who is online. Now, as an industry representative from the sectors that do get to work with extensively with personal data, what is the cost of data protection regulatory compliance? Because what we've seen across many African countries, not only in Southern Africa, that there is not a lot of compliance. But is there an advantage to compliance anyway?
Okay, thanks for that question. I think let me first start with the with perhaps the benefits. There's obviously a plethora of benefits for the adoption of enforcement or compliance to the data protection laws and policies. I think one of the panelists earlier talked about, data use limitations. There's things like security of the data quality, etc. But I think for me, the ones that I find quite relevant, and I think a lot of these, that long list can be whittled down to a couple of things. And the first thing is the protection of individuals' rights and civil liberties, of course. Firstly, this speaks to the right for consumers to have awareness of how their data is not only collected, but how it's shared and how it's actually even tracked. That is to say, how it's being processed holistically. Secondly, the privacy legislations can restrict governments, make no mistake, and law enforcement agencies from unscrupulously accessing private citizens' information. We've seen instances where governments do that through unwarranted invasions. So in jurisdictions where these laws are being adhered to, we see situations where even the police would need to get a warrant before collecting personal data. So that's one. And then the second thing under the benefits is the protection of vulnerable people from predatory online behaviors. And maybe I say vulnerable, but I should say the protection of all people from predatory online behaviors. So I think everyone listening to this would have read about or worst experienced firsthand how online exposure of identifiable information can be used to sabotage physical or mental well-being of individuals. We obviously summarize all of this into what we call cyberbullying. And so those two for me kind of do stick out. Now, if I shift my focus a little bit to, I think you asked about the potential cons or the disadvantages of the adoption of data protection laws. The first thing, which also serves as a deterrent for most companies at a company level, is the cost of compliance, which typically comes in a capital investment type form. And this sort of investment, whose return on investment is not immediately apparent to the corporation, besides just forced compliance, is a bit of a deterrent, and it's something that a lot of people see as a disadvantage or as a con. And certainly from my own personal vantage point, being in the business that I'm in, there's a case to be made for the role that is played by regulations, to these sort of regulations anyway, to stifle innovation to a certain extent. This obviously ultimately limits companies' abilities to realize their full creative and of course their entrepreneurial potential. You can see then that, with data privacy laws, the perception of a point as to whether it's either an advantage or a disadvantage depends on which side of the consumer corporation divide of interest you find yourself. So it's a bit of murky territory to that extent, to try and classify a point as whether an advantage or a disadvantage, because one has to take the context through which you are coming at. My opinion is that the solution, of course, then lies in striking a balance between, the organizational commercial interests and the consumer rights and freedoms, and reconciling these for those who are willing to cooperate, both on either side of that fence. What additionally makes the ecosystem even more complex is that, and what I find actually quite interesting at a personal level is that, by design, every time we talk about data protection, you realize that, by design, data networks have a global reach. They're global in their reach, and data protection policies are local, geographically speaking. And then, of course, the structure is what makes the compliance quite challenging for the authorities and the commissioners. So hence, earlier on, I spoke about the need for inter-jurisdictional collaboration on the drafting and of course, the enforcement of the protection laws. So I think I'll leave that question there. I'll take any follow-up questions if there's any that come through that.
Let me come to Nompelo. Nompelo, I want to take you back to a discussion that we heard earlier of punitive measures and how many of these data protection laws are not as punitive as would be expected, because it is about do this, don't do that. But putting in context of Angola, the Angola Data Protection Agency, which did go ahead to fine a bank for breaching the data protection sections, part of the data protection sections in the laws. Now, the question is, why does it become so hard for other countries to have such punitive laws? I mean, probably with the punishments that come, heavy punishments that come with it, then we might be in a place where we will have companies and countries respecting their own laws because they know there is a hefty punishment that comes with it.
Thank you so much for your question, Mildred. I think what I want to emphasize is that most of the laws have these punitive provisions in place, what should happen in the event of a breach or a violation of the provisions. But what we have seen as a gap is the gap in enforcing those provisions. And I think Hlengwa spoke at length about, particularly from the South African perspective, which could feed into why some of the African countries are also not utilizing some of those measures. And what I want to emphasize, maybe as a starting point, is that it's very clear that most of our data protection authorities who are responsible for the enforcement of those provisions or these laws have several mandates or have several roles and functions as part of their work. And this includes their awareness role or awareness mandate, but also there's the advisory role, because most of these authorities are advising also several government agencies and also their line ministry as well. And then there's that enforcement component. So because of that multiplicity of roles, it also becomes a challenge, particularly on the enforcement side. But also to highlight that what we have noted also from most of the data protection authorities in the region is a lack of capacity. One being the technical expertise or the capacity to identify talent or skilled people to undertake that work. So there's that lack of human resource that is there, that has been noted, but also a lack of financial resources as well. So you will note that, in order to fully realize the data protection and data privacy ecosystem, there's a need, to have sufficient resources for the enforcement of the laws, but the authorities are poorly resourced. And that lack of ability or the lack of resources then undermines their capacity to enforce. So that's one key issue also, which I think our governments would need to address or take into account, particularly when establishing these authorities, so that they are fully able to exercise their mandate. And also one thing that I want to emphasize on is that, and I think I spoke to it earlier, that normally when these data protection laws are put in place, they are setting out principles or a broader framework. But there's always a mandate of the Data Protection Authority to develop regulations that then elaborate on some of the issues or lay out the procedures and other key issues that would be pertinent to enforcement of the law. So what we have noted also, even what is happening currently in Zimbabwe, is that we have a data protection law, but we do not yet have regulations in place for the enforcement of that law. So for example, the law speaks about security breaches, that in the event of a security breach, the data processor or controller should notify the authority, but there's no procedure in terms of how the notice should be made, what nature of information should be included in the notice, what mechanisms should be put in place once a security breach has been noted or has been identified. And in other instances where the law speaks about data processors and controllers having information security mechanisms, I think Hlengwe spoke at length about that, about the correlation between cybersecurity and data protection and privacy. So where in other instances the law speaks about the need for controllers and processors to have some mechanisms in place that facilitate information security. You see that there's not much information in terms of the level of compliance or the bare minimum standards that the authority is expecting. So as a result, also that then really affects the enforcement and then also slows down their capacity to then enforce some of the punitive measures that would have been put in place. So these are some of the gaps that I've noted in the region. And I think there's opportunity also to develop the capacity further, not only of the data protection authorities, but even of the standard guidelines that most of the countries are putting in place.
For that particular discussion coming through. Let me run to Jimmy. Thank you, Nompilo. Jimmy, still bringing into context of journalism. On one side, you have the journalist who is trying to get data as a data collector. On the other side, you have the sources who are more like the data subjects. And in doing that, there is one aspect of freedom of information and how you're going to use it, and the privacy aspects coming through, and the freedom of expression. But on one hand, there are the sources who could be able to, use that against you as a journalist. So I am wondering how we can be able to strike a balance between the two.
Thanks for the question. I think as I spoke earlier, I think I alluded to the fact that striking the balance, I think, shouldn't be just a question of how a particular journalist, a particular media institution decide. This is where we're coming back to having a structured environment in which there's a legal framework that applies. So, for example, if you look at countries like the UK, for instance, they had to come up with some sort of guidelines for journalists and how they work around the issues of data protection in view of the data protection laws in the EU in those days. So without any legal framework, the problems comes in. But also without legal framework, I think would run into the the difficult territory in which you are now beginning to try and define who is a journalist, what is journalism, because online today, there's people are creating content, all sorts of content, to the point that it's not really straightforward what can constitute as journalism and what not. We've seen countries, for example, that actually taking advantage of people that have large following online and having to license bloggers, having to license content creators for whatever reason is there. So these issues are going to emerge even online. So yes, free expression, including freedom of the media, having independent press, all these basically are important issues to have a healthy democracy and having a healthy society. So to answer a question directly, I think media organizations, including journalists, must actually try and strike a balance between producing, independently producing journalistic content, content that is actually in the public interest, addressing issues affecting the society. So where you have a data protection law has to recognize the fact that under whatever circumstances, journalists have to use certain information. There's no journalism without data. There's no journalism without information. So the data protection laws have to recognize that, and media institutions themselves must be aware that they need to comply with aspects of those laws. But in absence of the law, I think is going to be chaotic, and governments and other institutions are definitely going to take advantage of journalistic institutions. So I think this calls also to media institutions actually to wake up to this reality that we need to have specific guidelines. These are important to protect journalism, but also to protect citizens as well. Thank you.
I think I'm in a class. I should say, Jimmy, it's picking up a leaf and a branch and an entire tree as a journalist, definitely here. There is always that compromise. There is always that conflicting loyalty. Sometimes you're between a rock and a hard place. There is disinformation. Sometimes it's personal. You have to release it. It's for the benefit of the country. And then you're thinking about the rights of the other person. So it becomes a little bit hard. But let me come to you, Helengiwe. Earlier, we were talking about the Protection of Persons Information Act, private information. And in this context, in the fourth industrial revolution is the digital economy that we will not take away. I want to tell you that in Uganda, currently, Facebook is still under lock and key, for lack of a better word. So it's VPNs. So for many people who were advertising and doing online businesses, they were immensely affected. Now, we know that in dealing with that, there is private information that has to be shared. For example, if I need a delivery, my house number, my card number, if I have to pay using a card, or my mobile number, because there has to be some transaction that has to be taking place. And yet Popia in South Africa is saying, in particular, if I could be able to take it up, it essentially says that a responsible party may not transfer personal information about a data subject to a third party who is in a foreign country unless certain protections are in place. Now, yes, I love the fact that it says unless certain protections are in place, but sometimes you can't be sure. And yet there has to be this digital economy that's moving on. Now, my question is, won't this be a restriction on movement of this data, which in the other end may rid South Africa of the full potential and benefits from a digital economy?
Thank you very much. I will have to respond very fast because I have another engagement. I thought by now the session will end. We look at the Protection of Personal Information Act, Section 72 of it talks about cross-border data transfers. And just to say that cross-border, the movement of data across borders, it's a normal part of the data protection ecosystem. But what the law says here in terms of Popia is that at least when that happens, the understanding is that when you process it inside South Africa, it will have been processed lawfully in terms of Popia using the established principles. And when that happens within the context of taking it outside the country, then the standards should also be in such a manner that the information is protected. And the conditions that are put there, it does restrict the transfer, but if that transfer has to happen, there are certain requirements that have to be made, and these include, there has to be adequate legal protection when you're looking at the party that is going to receive the information, that third party. At least there has to be a law, or there has to be some other binding rules as well that will ensure that the information that is transferred is also transferred lawfully, and its safety will be guaranteed, or it will be protected. And also the issue of consent that we had already been mentioning throughout the conversation, that if there has to be that transfer, that element of consent has to be considered. And also now you're looking at the why that transfer has to happen in relation to the data subject. Is it benefiting the data subject? Is it in the interest actually of the data subject? So yes, it is necessary. And so those are some of the restrictions that you would find in a normal data protection authority issues around cross-border transfer, that it also has to be regulated, which is a realization that yes, we process data within the jurisdiction, but because we are living in a connected world, we need to also transfer the data outside of the jurisdiction, but there has to be a regulation around that. But the challenge is that overly regulating or creating too many restrictive conditions then would undermine the flow of information and of data, and also the fact that there are some small entities, some of them are very small, to even deal with the requirements of other jurisdictions. So that capacity to deal with other jurisdictions, and then even the demands of it, of transferring, can be a challenge, and that then will create challenges around the flow of information, but basically looking at how the economy has been digitized. So the restrictions have to be there, but they have to be a balance so that they are not overly restrictive. And we also need, as we have been making reference to our data protection authorities, that they should provide the adequate guidance. So when you're looking at the South African context, the Data Protection Authority actually has a mandate to assist in providing guidance when it comes to transfer of data protection authorities, so that in as much as data protection is upheld, at the same time, it doesn't also, the restrictions do not disturb the flow of data, which data we have already acknowledged that it is very important within the context of digital economies.
Yeah, I know probably pretty soon we might be getting to lose you because you have another engagement. But thank you so much so far for the attention that you've given us. We'll take on I'll take on Bram and Oarabile for just one more question, and I'll be able to look through if we have a few of your questions coming through. Of course, I've seen just a few, and then we will be able to wind up the session for our panelists. But let me come back to you, Bram, still on the aspect of, earlier we were talking about the African Continental Free Trade Area, where there is not a little bit of harmonization on data protection, but many of the African countries across board, you clearly can see that in the constitution, there is an aspect of protection of rights, including information and personal information data of all the citizens. But when it goes down to specifics of data protection laws, there are either flaws or it's quite slow to have them, or the effectiveness of their implementation is a little bit hard. Now, how can the policy gaps in the personal data laws of Southern African states be addressed? Bram?
Okay, I thought Oarabile would jump in, but I think it's a very good. So my country, where I come from in Malawi, one of the issues that we have observed, and I think this is a problem generally across the board, if you look at countries within Africa, is that we are very slow to respond to technological issues, especially as far as the policy issues are concerned. Technology is always changing. 5 years ago, we were not talking about metaverse. And now here it is. You find that governments will have to go back and look at the policies and legislations that, are able to play in that sort of a field. This applies to even issues of making sure that our laws are up to date and they are always at par with the changing technologies within Africa. And of course, it has been alluded to in some other jurisdictions that maybe you'd find that in across Africa, sometimes governments focus more on the politics and then pay less attention to issues that are going to be there for many years, even after politicians come out of power and other politicians come in. So you'd find that that is our number one problem. Number two is that I think the lawmaking process in most of the African countries is a rigorous one, and it takes time. It takes the longest period, consultations. It goes here, it goes there. By the time we're passing the actual law, you'd find that already the law itself, needs to be updated because there are other issues that have emerged, while we were, discussing and deliberating what needs to be incorporated within the draft itself. And so it's a challenge, and I think maybe the best way to tackle it is to look at how other countries in I don't know, maybe in the global south, have been able to be at the forefront in making sure that the laws and legislations and policies are always speaking to the times that we live in as far as technology advancements are concerned. Thank you.
Thank you very much for that. Let me now get to Arabelle. In relation still to artificial intelligence, because I mean, that is what we're promoting every other time we're saving time, we're saving the money. And now, in what ways can Africa improve oversight for responsible use of artificial intelligence systems? Because what you said earlier pricked deep when you said, for example, Africa has become consumers and a testing ground for many of these technologies. And sometimes we forget about ourselves, we forget about our own agenda and how we can play oversight, and we're just welcoming this coming through. So in what ways can Africa promote or improve oversight and responsible use of these artificial intelligence systems?
Yeah, so thank you for that question. I think, it is evident from the above, emerging AI policy frameworks that I discussed earlier on, and how they are being adopted or deployed across Africa. And I think, some of these issues really center around data protection, which raises, that very core aspect of why AI technologies are being deployed in the society. For example, where strong personal data protection laws and effective oversight bodies can play this kind of role in countering, potential harms and risks in the society as well. Also, I think the focus on building, national AI ecosystems supported by the necessary data and computing infrastructures that we see across countries is key to countering, foreign tech influences on the continent in terms of the global digital discourse, as well as, promoting AI solutions that serve our local needs, African problems. Perhaps, on the business side as well, with this new concept of responsible or beneficial AI, private companies also have a role to play in this kind of discourse, where I think they can shape their business strategy, establish their governance models, creating systems that define how their organizations approach responsible AI practices, policies, and standards. I think with so much financial power as well in the hands of investors who fund these private companies, surely all that we can ask here is accountability, because the risk of damage really cuts both ways. Sometimes I think the whole concept of responsible AI technology is not really just to say it's the right thing to do, but at the same time, I think companies need to understand as well as the benefit they get out of this, putting up all these measures in place. But from the government side as well, I think through national AI strategies that are being developed, and as well as their practices of using these technologies, I think government can invest in establishing AI ethics and governance committees that kind of develop ethical standards and legal frameworks and analyze how these technologies can harm or perpetuate some form of bias or any risks in the society. I think, I normally give this example when I speak to people, and I refer to issues of ethics. The way we buy, the same way we buy a product and you get a user manual inside that packaging, I think, maybe how about we have the same approach to how companies also explain how their AI products process and collect data. So I think the same analogy can really apply in this kind of concept, which I think helps in some way to provide some form of transparency and accountability. And I think in addition to that, what we can emphasize is putting up measures for recourse where users and citizens feel aggrieved and that their rights are being violated. There's some form of processes and legal route to take to to hold people into who are in power to account. But also from the civil society perspective, I think organizations involved in this work should invest more in programs as well as advocacy initiatives that center their work around holding those that are in power to account in how these technologies are harming our societies. I think I'll just stop there in case there are any follow-up questions.
All right, thank you very much to all our panelists. It's great a discussion, and I feel like we should continue for more and more hours, but our time is really fast spent and it is running out. I think I need to take off some time to be able to pick up some questions, and I am already seeing some of them. Now, this is coming in from Abdi Fatah Ali, who says, when is such a discussion on the data protection laws in East Africa happening? Or he's actually trying to find out when such a same discussion will actually be coming through. And I think, Abdi Fatah, I can clearly respond to that question. The East and Central African Privacy Regional Engagement is going to be coming through on the 5th of August. So if you want to get to know what is happening in East Africa, please make sure that you make a date with us. So 5th of August is when we will be having that. Okay, so this is Fatma Songoro, who is asking any of the speakers, and so I'll allow all our speakers who are still online to be able to respond to this. Fatma is asking, in adopting data protection systems and management, what do you think is the best model between data privacy by design or by default? What's the best model? So I will ask that to all our panelists, please prepare an answer to that in your own perspective. And this one is going out to Jimmy. So Jimmy, how do we balance the need to be identified in SIM card registration, national IDs, for example, and the need to protect our personal data? This is coming in from Moses Chisulo. And Jimmy, let me come to you directly. You can answer this one coming in from Moses Chisulo, who is asking, how do we balance the need to be identified in SIM card registration, national ID, for example, and the need to protect our personal data? And you can also give your 2 cents on the question from Fatma, which is asking the best model between data privacy by design or by default. Jimmy, let me start off with you.
I think I'll start with the question from Moses. I think the key issue is having a framework, legal framework in which people are aware, people know how their data is going to be stored, who's responsible for that storage, and how secure that data is. And in any case, if somebody wants to have access to information, there should be a procedure in which that information can be accessed. So the key issue really about data protection is not whether you should provide your information for SIM card registration, for example, which is mandatory. If you can't register SIM card, you can't communicate in that sense. So it's a question of maybe before we start or before we embark on these projects of massive data collection, we need to have a legal framework that protects people's data. The second point, I think the question of default can be very difficult, but I think it's better to design data protection frameworks because, as we've seen from this discussion here, that there are several things that we have to consider. So, in particular, the technologies that we're talking about that are changing all the time, and these are human-designed technologies. So I think I'll not go for a default one, but maybe design. Thank you.
Thank you very much, Jimmy. And I think I'll give you just 1 minute before I go to Ogone for your closing remarks as we get to close of this. What are your parting shots? Jimmy.
Yeah, I just wanted to say thank you to Anointed Witness for organizing this and for inviting me. And I think you did very well to get to this distinguished panel of people. I've learned a lot, and I'm sure people out there that have also learned quite a lot. But I have to say this, that I think as Africans, we need to get to the point where we realize that we can't afford to have this conversation amongst ourselves. If you look at the panel here, I could point out maybe to several people that I've actually met before. So we have a cycle in which we discuss these issues time and again, but we need to take these issues seriously. We need to take these issues to the people out there as well. So it doesn't become just a niche, exclusive club discussing these issues time and again and again. So I'll stop there. Thank you.
All right, thank you very much. Ogone, I know you will be leaving us pretty soon, but I will be expecting your parting shots. But also, as you give us your parting shots, you could as well respond to what Fatma did ask here on what do you think the best model between data privacy by design or by default. You could as well give us your parting shots. Ogone?
Yeah, thank you for that. I think to the question, I would say certainly it's got to be by design and it's got to be deliberate, and that is my opinion on it. Because if you leave it to fester by its own self, then you're leaving too much to chance, and sometimes the repercussions and the punitive measures that come out of a lack of compliance with data compliance can be quite dire for the organization. In terms of my parting shot, I'm really happy to have been a part of this panel. I think it's as my learned gentleman Jimmy was saying, it's time that we start to have these conversations a lot more. As Africans, I think it's important that we actually start to lead the charge and not only hear about the major, the examples we can give now are largely those of the Cambridge Analyticas of this world. Meanwhile, a lot of these breaches are actually happening in our own backyard, but we don't shine enough light on them to actually sensitize awareness for other entities or organizations that could actually learn from that. So these sort of collaborations are quite critical, and I'm excited and happy to have been a part of this. I thank you very much.
Gone. I'm wondering whether Nompilo is still there. Nompilo, you could have your 2 cents on the question that did come through and give us your parting shots too as well. Nompilo, are you still with us? Or, okay, I think we lost Nompilo. Hilengiwe still online? Hilengiwe Dube, are you still online for your parting shot? You earlier had indicated that you wanted to leave. All right, I think we've also, Hilengiwe left through. Bram, let me come to you for your parting shots, but also your 2 cents on the question that was raised earlier on the best design, whether by default or design, data privacy. Bram?
Sorry, can you come again? I just actually, I lost connection. I just joined again, back in.
Again. All right, Bram, there's a question that was coming through from one of the participants right here. And if I could read it to you verbatim, Fatma Songoro is asking, in adopting data protection system and management, what do you think is the best model between data privacy by design or default? And you could give us your parting shots too.
I think by default would imply that we are comfortable with the default design aspect, and whether that default aspect took care of the because when you're putting the human at the center of the design itself, then you have understood all corners of how the privacy and protection should actually address all issues. So it would depend. I wouldn't say which model is actually the best, but I think in my opinion, design by design would have to also place the data subject in this context at the center of the design itself, and then come up with a model that is best for the data subject, but also all the stakeholders that are involved in the collection and processing of the data itself.
As well as your parting shots.
Come again?
The same question that is coming in, Orabile, the same question that is coming in from Fatma, in adopting data protection system and management, what do you think is the best model between data privacy? Is it by design or by default?
I mean, addressing that question from the perspective of AI, which I've spoken a little bit more about in this dialogue, I think by default, it basically means integrating privacy in the full life cycle of a system, or how it operates, and even the product, the way it's being used. But also, I think I need to emphasize that it is important to remember that this kind of fundamental reasons behind this approach help ensure that, you know, privacy rights are also catered for in that particular life cycle of a product. But also, in conclusion, I think I wanted to say, you know, when you look at emerging debates in the global discourse around data governance and, you know, digital policy, they've kind of really been centered around data sovereignty or digital sovereignty and the controversies around it, not only from the global north perspective, but also in the global south perspective, where we have seen different countries across Africa developing this data policy frameworks as drafts or bills. And perhaps, you know, as a takeaway from this discussion, the question today is not whether our data is or should be regulated at all, but what and how. And if that's the way to go, what should be then the model of governing this kind of technologies? Thank you.
All right, and we can be able to have your parting shots too, or Belay as well, as we get to end of the discussion.
Yeah, thank you so much for having me in this discussion, and I hope that, you know, we will take it beyond this kind of platforms, engage with different stakeholders across the continent, as well as, you know, discussing these issues to see how they bring effects into our communities. Thanks again to my fellow panelists for their great submissions. Thanks.
All right, thank you very much, Orabile. Maybe we'll finalize this with Hailu. Hailu, earlier on we did talk about, you know, the curriculum, the lean data protection curriculum, which you extensively explained about in companies being able to get the information on the data that they exactly need. But one more is what exactly could have informed Mozilla's decision to start engaging university engineering students on privacy and the LDP concept, that's the lean data protection concept that we earlier on talked about.
Thank you for this question. With the creation of the Lean Data Practices curriculum, our goal is now to promote awareness of the course. It's tailored towards startups, entrepreneurs, and SMEs in the region. In discussion with our partners and stakeholders in this space across Africa, the message that came out was really that there's a lack of awareness around issues of data protection, of ensuring privacy is baked into startups' operating models and their business operations. And so engaging with university students and graduate students is a way to reach a critical group that is and will be increasingly involved in this space. Beyond engineering students, we're also interested in reaching business students, those who are studying entrepreneurship, cybersecurity, et cetera, because these are the young folk who will be creating innovating apps, who are already creating innovative apps, who are going to be innovating businesses using technology, and who'll work in various types of industries and for companies or organizations that invariably collect sensitive and personal data. So encouraging awareness of the Lean Data Practices framework of this course, supporting them to gain access to these types of skills around best practices for data collection, around privacy, and how they can be incorporated into their companies. That's really our goal.
All right, thank you very much, Hailu, for that. And it's been quite an engaging one and very insightful a discussion about how Southern African countries are dealing with data protection and privacy. And the key issues that did come through here, particularly aspects, Nompilo talks about the lack of capacity, especially the human resource to be able to, or the workforce to enforce the laws that are put in place and the financial resources that are also needed. Also came in the aspect of organizations And this particularly came in from Helengiwe from South Africa, talking about governments coming through and implementing bodies coming through to assist organizations to be able to fulfill these laws and regulations that are in place, literally show them how to be able to do it, as opposed to just bringing out the stickers and when they cannot be able to do it. And Jimmy clearly pointed to an aspect of, most people not even knowing what data protection is. For me, I want to just provide my information. If I want my lunch meal delivered, I can tell you my house number, I can tell you the street address and everything. I don't even know about data protection at the end of the day. And also clearly speaks to a very key aspect that these discussions shouldn't just be amongst ourselves, but we should expand the discussions to go right outside so that so many people get to benefit from them. Bram did talk about stakeholder involvement, especially from the drafting stages and making sure that everyone is involved. Do not bring us in when we have to give our views after everything is done, but let us be involved from the beginning and also have better technological innovations, for example, in dealing with the African Continental Free Trade Area, because the digital space is the now and the tomorrow. We cannot run away from it. Hailu also brought in the aspect of the lean data protection, the LDP, lean data mechanism, whereby a company should only be able to get information that they need. I mean, you don't need all these 25 questions, and yet for you to be able to design your services and concepts, you'll only need about 5 of the answers of the 25. So you really need to have that, but also choice and control by the user is very key. And this, I think, loops into the discussion of artificial intelligence that Oarabella did talk about, that even while providing these artificial intelligence systems, we should have sort of a user manual where I can be able to look through and be able to find out what exactly is being provided. And most especially, given the fact that Africa is used as a testing ground for many of these things. So a lot that did come through, you can, since this has been recorded, we'll be able to share it out and you can be able to look back on what the discussions have been. Now, earlier on, we asked for the poll questions. We asked about some poll questions, interesting questions that did come through. Some of the answers have also been interesting. Let's get the poll results right about this time. What were the answers that you gave us? Now, one of the questions was, which of the following is not personal data? And 15% of you said it's students' examination results, 30% of you said location, and 56% said company registration number. And well, the answer is company registration number, which is right. That is not personal information. That is not to a person. Okay, we go to question number 2. Do you know who to report to if your data is being misused? Well, it's interesting that many are saying yes, 70%, and no, 30%, but well, most likely not. Most likely not many of us know where to be able to go. And the third and last question came through as how many countries in Southern Africa don't have data protection laws? You had to take one single choice. Well, we had quite a number of, countries that did exist right there, but I can see your scores at 19, 30, 26% right there, still guessing which Southern African country has a data protection law and which one doesn't have a data protection law. So thank you so much for all your engagement. Just reminding you that this was recorded, and we have on the 5th of August, the Eastern discussion, Eastern and Southern, Eastern African policy, privacy engagements such as this on the 5th of August. So we're gearing up to see what East Africa is doing and what all those other countries are doing in terms of the regulations and the implementation of those in place. Now, we just want to remind you a little bit, because we have the Privacy Symposium Africa, the 4th edition, that is going to be happening in Nairobi. Nairobi, we are coming, Kenya. Yes, you will be hosting us at the prestigious Strathmore University. But on the final day of the Privacy Symposium Africa, on the 3rd day, like we said, it was a hybrid. But on the 3rd day is when we had the release of the report. That is when we got to know which companies, which organizations are in line with data protection and those that are not. And not to be able to shame them, but just to be able to tell them, you're not doing good, you need to do better at the end of the day. Let's get you some of those highlights of the 3rd Privacy Symposium Africa that it happened right here in Kampala last year, 2021. Take a look.
and partners for being actively involved in raising awareness about data privacy through establishing a critical knowledge sharing platform codenamed Privacy Symposium Africa.
Shape the practice and policy of data protection, because data protection and privacy is who we are. It identifies us and it's our safety and our lives as well.
We're going to have a panel discussion, and for most of our panelists, I think are going to be live, and some of them will be virtual.
This panel will be on smart city governance, citizens' privacy, and services.
The role of government to ensure both the protection of the private individual and public interest. And aware of that, in the dawn of the new technology for which we are discussing right now, there's been a lot of advantages for which really individuals have exploited for their personal gains. But besides that, this has come with a cost of compromising public security. Therefore, like my colleague has come in, government entities like NITA come in to do regulate both the individual and private interests.
The one level is at policy level. So obviously in policy implementation, you increase the space for public participation so that the design of policy is risk first. And in order to do that, you need to include conversations with the people who are at risk.
But for me, balancing it, first of all, we would need to create proper legislation. And speaking about Africa in general, I understand that only, I think, 24 countries have data protection legislation. So we need this to grow and cover the entire Africa. And then the regulators should enforce these laws strictly, and they shouldn't just pay lip service to them. You'll be pleased to know that for purposes of the Uganda Data Protection Act, actually, some of the things were anticipated. There is a provision on automated decision making. If you're going to make decisions that affect citizens by automated means, then there are processes to follow. So these things should be enforced and not given just lip service.
The third privacy symposium has shown how the collaboration between government and civil society can work together to ensure we create the much needed awareness on personal data protection and privacy matters, and also raise the need for compliance for those collecting, processing, holding and using personal data.
And I'm here to present the Privacy Scorecard Report. Now, the Privacy Scorecard Report is assessing 32 data collections. The Privacy Scorecard Report is a monitoring tool used to provide Ugandans with critical information
on how
that is exactly what happened last year in Uganda while we had the Privacy Symposium Africa, the 3rd edition right here in Kampala. We will be giving you a bit of this as well in the next year, showing you what exactly should have happened in Nairobi at Strathmore University. But we'll continue with the regional engagement, still talking about data protection and privacy. This is an aspect that applies to each and every one of us. If you are using something like this, which is a smartphone, at one point in time, you're giving in your data because you want a transportation app, or it is e-commerce, you're trying to buy something online, or it could even be food, you're trying to order something online. You're giving out your information each and every day, willingly or unknowingly, but at the end of the day, your focus should be on how that data is protected and not misused at the end of the day. For everyone who joined us right here for this Southern African engagement, thank you so much. It's been a pleasure. This was recorded and much later on. Unwanted Witness and Strathmore University will definitely be able to provide all the information in case you want to recap on the discussions that did come through. Particular thank you to all our panelists who did come through from Botswana. We did have Ogone from Zimbabwe, Nompilo Simanje. Thank you so much. We did have from Malawi, Jimmy Kainja. From South Africa, Hlengiwe Dube. We did have Bram Fuzulani from Malawi as well. And Halo did come to us live from the United States, and from Botswana, Warabile Modongo. Thank you so much for joining us. Now, for more information and communication on the events that will be coming up, you can follow us on our social media platforms. For Privacy Symposium Africa, you can follow us on Facebook and Twitter. That's at Africa Privacy. Once again, on Facebook and Twitter for the Privacy Symposium, you can follow us at Africa Privacy, because many people probably thought this was the Privacy Symposium. And the website is privacysymposiumafrica.com. privacysymposiumafrica.com. You'll be able to get all the information about the forthcoming Privacy Symposium. Like Alan did clearly say earlier on, this will be by invite. So you need to know how you can get invited. Hit to that particular website and get all the information. From us at Unwanted Witness as well, if you want to get in touch with us on Twitter and Facebook. On Twitter, you'll find us at Unwanted Witness, and on Facebook at Unwanted Witness UG. But our website as well is unwantedwitness.org. You will be able to get us and get all the information about the work that we do and the reports that have been done. And you could be able to just recap and get that information. And CPIT as well from Strathmore University. You can get us on Strath CPIT, that is on Twitter. Strath CPIT, that is Strathmore, the short form of Strath, and CPIT as well. And on a website, you can get us at cpit.strathmore.edu. Once again, cpit.strathmore.edu. You can get all the information that you need to know, and we will also keep you in the loop for all those who did organize, for all those who did log in, or for all those who did register. We'll make sure that we give you all this information. For myself, Mildred Tohaise, and the entire crew from Unwanted Witness, and Strathmore University, we want to say thank you so much for being a part of this. May God bless you. A lovely weekend from the Pearl of Africa. We love you, and God bless you.
On behalf of Unwanted Witness, I take the pleasure to welcome you all to this 3rd edition of the Privacy Symposium Africa 2021.
We acknowledge that businesses and governments need personal data to be able to identify us, to provide services, to understand our needs, to improve the services they provide to us, and many other objectives. However, the personal information must be collected